It doesn't matter what year you are. I'm head of the associates. If I give you an assignment, you do it.
Hey, everybody. This is your daily dose of all things royal. Welcome back, my gorgeous, good looking friends. It looks like we got trouble brewing for Mr. Harry Windsor. The American citizens seem to be paying attention, which makes me very happy to see because Prince Harry is definitely a public nuisance in the United States. The buzz online is that there are people inquiring about Prince Harry's admitted substance usage on his application to get a visa. And one reporter, journalist, American by the way, not the British tabloids, are requesting that that information be made public because it is of public interest. So a gentleman by the name of Mike Howell from the Heritage Foundation was the one who submitted a request to our Department of Homeland Security on March 8th, in accordance with the Freedom of Information Act, in which he copied the National Records Center for U.S. Citizenship and Immigration Services. The request is for expedited processing for the FOIA request to understand whether Prince Harry was properly vetted prior to or during admission into the United States. National media outlets have widely reported on Prince Harry's substance use, which, pursuant to the Immigration and Nationality Act, should make him inadmissible to the United States absent the requisite waiver available to non-immigrants. So the purpose of this exercise is to vet out whether the border officials did know. And in Harry's case, it raises questions over whether he was given special treatment because he is a prince and his wife is a celebrity in Hollywood, which would be actually illegal and probably not look good on DHS. So the question is, did DHS know about this and did they give him a pass, or did Harry lie? Either way, the outcome is not going to be good. And it says at the bottom here, the widespread media interest in Prince Harry's substance use inevitably raises possible questions regarding his application for residency in the United States and maybe down the road if he is looking to become a citizen. Moreover, if Prince Harry was granted preferential treatment, that too would undermine public confidence in DHS, CPB, and USCIS's application of equal justice under the law. Expedition is warranted. And the reason why this is coming to light and bubbling up in the media is because the very next day, I think less than 24 hours, DHS, our government entity, shot it down immediately. So now the Heritage Foundation fired back with an appeal put in place, attaching 140 pages of evidence as to why the public needs to know.
We've surely got trouble. We surely got trouble. Right here in the city. Right here. Gotta figure out a way to keep the young ones moral after school. Children's gonna have trouble.
That's right, we got trouble right here in all our cities. So who is the Heritage Foundation? They are an organization that's dedicated to supporting our Constitution, something that would be now seen today as conservative right-wing, sadly. This is important to the American people, and a spotlight be shined on it. I've said this before, that this man has come to our country, disrespected it, as well as now trying to infect the youth with ideologies that are dangerous and divisive, causing our society to break down, allowing for him and his stupid wife to profit. This has always been my issue with these two, of how they exploit and take advantage of vulnerable people for their own benefit. So yeah, I'm glad that this is happening. And I do want to talk about this case that he has going on with the Home Office, because I don't think people fully understand his reasonings behind what he put in the case, because we have been so distracted by all these other lawsuits and the other bullshit noise of the titles and coronation. Will they go? Won't they go? Guys, again, we need to stay focused on this case, because what he's trying to get away with is truly about being untouchable and above the law. So let's go back to the judgment that was issued on July 22nd, allowing this case to move forward. For me, the curiosity is around what was the justification to allow this court case to continue instead of being thrown out, because many would agree that this case should be thrown out as it's a waste of time and it's a waste of money. Unfortunately, the court system in the UK is not as transparent as the court system in the United States. Majority of information the public is not privy to. The only thing that we have to go on is the judgments that were handed down based off of the information that was given, which a lot of it we don't know. So from reading this document, it does appear to me that the approval for judicial review, which I'm not really sure what entails that process, technicalities, and my guess is this is to portray that the system is really balanced and being fair, which no argument there. And in one of these cases, I do agree, such as in bullet point number 3, the extent the claimant, meaning Harry, contends that as a matter of fairness, he should have been told the contents of RAVAC's policy before the February 2020 decision was made. And I would agree with that. If he didn't know what the decision criteria was going to be and how they work and operate, if he truly didn't know, which why would he know since it's not like he has done this before? I think it's reasonable for anybody to want to know how the process works, especially if you've never gone through it before. So that's fair. The other one that I'm sort of in agreement with, but not 100%, is bullet number 4. And it states here that the claimant, Harry, contends that prior to the February 2020 decision, he should have had the opportunity to make representations to RAVAC, including the opportunity to comment on other information RAVAC considered. I'm going to say yes and no. One, no, I don't think that he should have had opportunity if they gave a decision or in the direction of saying no, that he should have been able to come before the RAVAC panel or committee to refute the reasons why they're wrong and he's right. We all know that he wasn't going to take no for an answer. What I do think would have been fair is if after the decision was made, which I believe this is kind of where this all went, was to list the reasons for why they are being denied, and then give the opportunity to appeal the decision and come back to present it. Now, here's the issue with this. Had they had done that, or when this decision was handed down, why didn't Harry immediately submit to the government to fight for this? Instead, he waited months and months in order to contest this. And I think that that's where there is a bit of gray area, because if it was so important and they denied him in February of 2020, why didn't he immediately champion to appeal it and take it further? That's the only thing that I am seeing is the issue with this. It almost seems that after the fact, when everything started to go south and realizing how expensive security is, and also realizing that they don't have access to certain resources of intelligence in order to fight their campaign against their critics, is when they decided to apply for this again, realizing that that status held a lot of power and weight. In my opinion, just looking and reading this and just thinking through what I know, I think there's a lot of manipulation going on here, especially with the media and the PR spin that they're trying to push out there with the Spare Book and Netflix. There are bold-faced lies that Harry is telling to the public, in which it does appear that the strategy that they're using is putting pressure in the media to put pressure onto these judges in order to make their decisions. So the court of public opinion is really what these two have been doing with these court cases in influencing the outcome that they want. We see this happen over and over. They force the hand of others by putting pressure within the media. And this is what I mean when Meghan and Harry use the media and they weaponize it in order to get what they want. Remember when Meghan won her case against the Associated Newspaper back in 2021 of November, the United States really had no idea what was going on. and really did believe that narrative that she had painted around her father being so cruel and horrible. Any decision otherwise could have affected, from a political perspective, those judges. So, whether or not they felt that the decision that they gave was fair, I believe that they caved to the pressure of cancel culture. So, had Meghan been found guilty and they moved forward with a trial with A&L, there would have been a tremendous amount of backlash considering of all the propaganda that had been pushed out. Do you think all the white judges that were part of that case wanted to be called racist? Because you know that that would have been the first thing that Meghan's PR team would have spun out and pushed out to the Twitter bots and the people that are being paid to create this echo chamber to smear and damage others. No, they didn't want that. And so they found a technicality that would suffice in how many words they used from the actual letter, which that really was grasping, but suffice to keep this beast at bay. This situation is no different, and we need to put a stop to it, and we need to highlight the facts. The biggest manipulation and lie being told is Harry's offer in the Sandringham meeting that he was going to pay for his own security. Let me read to you what the court documents specifically state and then show you how Harry and Meghan have been pushing a different narrative. So let's go back to that judgment that was handed down by the judge, Justice Swift, dated on July 22nd, 2022. Keep in mind, this is the judge summarizing the facts as he understands it. As you can see here, it specifically states that the claimant, Prince Harry, was seeking permission to apply for judicial review of decisions concerning the arrangements to be made for police-provided, publicly funded personal protective security for him when he's in Great Britain. Notice the word there, publicly funded. It doesn't say police provided, but privately funded by him. As you can see, there was an expectation for the public to fund this. In the next paragraph, the judge shows that he understands Harry's position now within the institution, saying that until April of 2020, the claimant, Harry, was a working member of the royal family. So he was an employee of the royal family, in the role undertaking a range of duties on behalf of Her Majesty the Queen. That was his job. You see at the bottom, it says one aspect of these new arrangements is that the claimant, Prince Harry, no longer undertakes representative duties on behalf of Her Majesty the Queen. In other words, Harry is no longer working for the company anymore, which means all the perks and benefits to working for the company and representing the Queen is no longer applicable. Here's what Has said on Oprah.
I then got told, short notice, that security was going to be removed.
So in the summary judgment, the judge states that the decision to remove security was in a letter dated February 28, 2020. As you can see, Harry had a month to get himself together, and there's no doubt in my mind that there would have been a transition path for him set out in order to have private security, and I'm sure from a family perspective, his grandmother and his father would have helped him get to a place where he had the appropriate resources from a private capacity standpoint within the window of time that he felt was so short, which a month is really not that short. And again, in this same topic with Oprah, Harry decides to leave a few details out. Here is what Harry says when Oprah asks him, "Why was your security taken away?"
Their justification is a change in status, of which I pushed back and said, well, is there a change of threat or risk?
Now pay close attention to what he says.
And after many weeks of waiting, eventually I got the confirmation that no, the risk and threat hasn't changed.
Now, as we know, we have to fact check everything that comes out of these two mouths because they are the worst source of truth. We have to rely on the court documents for a source of truth. This is what the letter said. So going back to this judgment summary, the judge includes what was said in that letter from February 28, 2020, that went to Sir Edward Young, who was the private secretary to Her Majesty the Queen, and Prince Harry, the claimant, got a copy of the letter. So he knew what was being said. In it, it talks about RAVAC's essential focus and who are considered to be at sufficient risk to justify publicly funded measures to mitigate that risk. RAVAC is responsible for risks arising within Great Britain as they affect principals who are, in almost every case, resident within Great Britain. The future arrangements for the Duke and Duchess of Sussex do not fit readily within this framework, meaning they were not living in Great Britain. So going back to Oprah, Harry does share with the world the type of security that he has. And this is the security that he is fighting for in this case.
So what security did you have at the time that was going to be removed?
We had our UK security.
So here is where Harry has been deceitful and not forthcoming and honest with this story. RAVAC stated that they will continue to monitor the security of the Sussex family, including through periodic threat assessments. Should anything change in terms of specific threat, this will be commissioned to the Home Office through established channels with the police and intelligence partners like the CIA, Canada's CIA, and anywhere else that they go, and actioned as necessary. So guys, these two sat there on Oprah basically saying that their risk and their threat level hasn't changed, even though that was a lie because they had been running these assessments and telling people that they pulled their security away because they were no longer working royals, but the threat level remained the same, which was a bold-faced lie. When you look at the decision criteria that was laid out in this letter, in plain English, which I understood, I think the average person would understand, it states here, with the change in the roles of the Duke and Duchess, the existing provision of whatever that special name is by the Metropolitan Police Service will no longer be appropriate and will be withdrawn by no later than March 31st, 2020. Okay. The decision criteria: 1, they weren't living in Great Britain. 2, they were not carrying out work on behalf of Her Majesty the Queen. And 3, there was no risk being posed to them or threat being posed to them because they've been actively monitoring it. So what don't you understand, Harry? They were very clear, and it says, against the background set out above, there is no basis for publicly funded security support for the Duke and Duchess within Great Britain in relation to whatever it is that they can't show in confidentiality. But here's the thing, they weren't going to leave them high and dry. And in my opinion, they were being more than understanding of the situation, because even though now they were saying at this time in the present moment, we don't see any threat or need to supply you with publicly funded special security, but that doesn't mean things won't change in the future. And here's what they say. It is difficult, however, to judge what might be appropriate without knowing the Duke of Sussex's forward program or what private arrangements, if any, are being made for his security in Great Britain to link with and complement those which are being put in place in Canada. It may be sensible to put in place arrangements between Her Majesty the Queen's private office, the MPS, and the Home Office to look periodically at any forward engagements that may potentially warrant additional security attention. And going up and beyond to try and reach a compromise, the suggestion was there be a meeting with the 3 groups to follow up these detailed points which the Home Office might convene, meaning in the future, if there's some reasonable explanation why they need the security, then it would be considered. In the light of that meeting, I would then intend to look at what guidance should be issued about the support to be provided and the mechanisms for liaison and the approval of support in individual cases. What was wrong with that? As you can see, this has nothing to do with not feeling safe or having the right protection, because Britain was going to give it to them on a case-by-case basis, and they were still actively monitoring him. I'm going to show you that in a second, the reasons why he wants his status back. But first, let me finish showing you how he has been manipulating this situation. So continuing on in this judgment, this part really made me laugh because it just shows how manipulative he was being in trying to convince or make the case as to why he should continue having this type of security or feel entitled to be having the security. Keep in mind that the claimant is Harry and the defendant is the Home Office and the Queen. And what this judge was saying was that he did not approve or give permission to force the defendant to consider as part of their decision criteria this below paragraph. I'm floored by this. So it says, the fact that the claimant Harry sought to remain a working member of the royal family undertaking part-time duties on behalf of Her Majesty the Queen, the claimant, Prince Harry, conveyed or communicated his preference to members of the royal household at the Sandringham meeting on January 13th, 2020, which reflected this occasional representation or half-in, half-out model proposed in the draft table sent to the claimant on January 11th. The claimant, Prince Harry, was told this hybrid model was an unrealistic option. So essentially what is being said here, and this is how everything started to unravel for Harry with these 5 options, was initially he presented this scenario of half in, half out, and the fact that he made the attempt to continue to keep working in the family should be a decision criteria element that he wants the judge to force the defendant to take in consideration in this security bid. Do you see how mental this is? Wow. Wow. And they're pretty much outright telling him, no, this is not an option. Boom. There was no 5 options he was given. They told him no, right out the gate. But the fact that he had the intention to continue to keep working, that was his intention, that they should consider that also as a factor? Get the f*** out of here. It should be noted that after that February 2020 decision, they kept their end of the bargain and were monitoring the family. They gave him the security when he came over for Prince Philip's funeral. They also gave him a certain level of security when he came over in July 2021 for the unveiling of the Diana statue. Apparently, in his visit to do the Diana unveiling of the statue, it wasn't good enough because they didn't give him the full-on court press of the security guards and resources that he felt he was entitled to. Hence the reason why there was another case that was raised challenging the way that they were handling this back in September of 2021. So this time around with this complaint that Harry has pushed forward was that the REVEC policy was applied in an overly rigid and inflexible manner, meaning that it should bend to favor him, in which he didn't like the February 2020 decision and didn't like the 2021 decision on the resources that he was going to get on this individual case basis, as they had been continuing to monitor and survey if he was really under any threat, which he wasn't. I assume Harry didn't like the rigidity of the parameters that were put in place in the resources that were being given to him, such as not being able to have security if he wanted to go out to the club or do anything scandalous. He felt he was entitled to privacy and didn't want all those paparazzi chasing him, which up to this point, there still has yet to be proven that they had been chased in the manner that he thinks is parallel to the way that Diana was chased. The other part in this judgment summary that I found absolutely hysterical that the judge shot down was this part where it said, the claimant's or Harry's submission rests on Section 3 of the Succession to the Crown Act 2013, which provides a person who is in the line of succession, 6 persons, to the crown must obtain the consent of Her Majesty before marrying. So you might think to yourself, what the heck does that have to do with REVEC's policy and decision? It doesn't, guys. This is the funny part about it. He felt that because he was in the line of succession and he had to get permission by the queen to marry this broad, then he felt that he was entitled to this and that the Met Police had to give him those resources. So it says here, the ground of challenge is not arguable. The defendant, the Home Office, submits, and I accept, meaning I agree, that when deciding when and to whom to provide protective security, Ravak is acting in exercise of the Home Office or defendant's common law powers, specifically her power to maintain the peace. The claimant's, Harry's, submission was that decisions were taken in exercise of powers under Section 36 and 48 of the Police Act 1996. Now, for those that don't understand what those provisions were, it essentially says that it is at the discretion of the police to make that judgment on whether or not they can give extra funding to circumstances that come up, and this would qualify. So essentially what they're doing is manipulating the fact that because the Queen gave permission for him to marry and he was in the line of succession, sixth in line at the time, that the police should give additional funds because it's deemed worthy. And the judge is saying, I do not accept that submission. Those provisions are inept to cover either the function that is being performed or the purpose being pursued. Be that as it may, there is no arguable connection between the provision of protective security and the consent to marriage provision at Section 3 of the 2013 Act. The 2013 Act self-evidently contains no provision that, whether expressly or by necessary implication, impinges on Ravak's activities in approaching its own task of deciding which persons in what circumstances can be provided with protective security. Ravak was subject to the usual public law standards entitled to decide for itself which persons within the line of succession to the crown should fall within, which I have termed Category 1, which they didn't fall into it. There is no arguable case that Ravak was required to regard the class of persons described at Section 3 of the 2013 Act as a relevant consideration. This fool thought that because he asked for permission under this act, that the police needed to consider making the exception to allocate public funds because they have the capacity to do so? On what planet does this guy live on? Just curious. It almost appears that they were like throwing up anything to see what sticks. And what came back with, in order to get approval to have a judicial review, was based off of what I shared with you in the very beginning, was because the technicalities that he was not shared the policy ahead of time. They didn't go through and allow him to counter before they made a decision. I mean, it's little things that have come up, not so much the substance of this evidence. Now, when you look at the facts, or as you see this case evolve, what you're starting to understand is that all the stories that he has been telling in the media is to back into now what he probably has submitted in updating this case, which we don't know. We haven't seen. So he has the go-ahead to update this case with additional facts. What is very clear here that I'm not sure anybody has pointed out, but if he is assuming that the Police Act of 1996 has the discretion to give funds to off a la carte situations based off of those sections, then how can he say that he was willing to pay for security on his own if he's suggesting that the police has this clause in which they can get funds to pay for the security? Now, I'm willing to bet that in the next version or updated in the skeleton argument, which we won't see because this stuff in the UK is not as transparent as the courts here in the US, is that they're going to now include the titles of Archie and Lily books into the mix, saying that now they have 3 people in their household, which should grant them this protective security, because now you have 3 people in the line of succession that could be at risk if they don't have this 24/7 security. Do you see how they are maneuvering to get their way? This is why the king needs to shut this down. And it's not going to be very good if this does happen and they get this IPP status.
The issue that Prince Harry, well, the Duke of Sussex, or the Sussexes are having now is trying to actually access intimate and very highly sensitive information that only the police are privy to because of the nature of private security and how it operates in the UK as opposed to in the US.
Remember Danger Zone? Sweet Ashley? Remember, she was one of the first that spoke out about Harry and Meghan and all the deceitful things that they were doing. And subsequently, all those Sussex terrorists that Meghan and Harry are funding or were funding had went after her. Is it a coincidence or suspect that her mother's house burned down, her house burned down, her dog was killed? Now, were Meghan and Harry connected to those incidents? Nobody knows, but it is possible. Ashley was stalked, harassed, like some of the other YouTubers, where, they had her information, just like Murky Meg, according to Taz and Yankee Wally. It wouldn't surprise me if, when they had this particular special security, that they had access, which they do, to Scotland Yard in finding out where all of them had lived and giving it off to their minions to go ahead and threaten her. This I totally believe, because we know that the Sussexes are paying these people. Well, probably not as many now, but we have the evidence that the Sussex camp fund and support them. I wouldn't be surprised if they had access to Ashley's data, Murky's data, Yankee's data, Taz's data early on, to a point where they had their army go out and carry out these campaigns. I think it frustrates them that they can't silence people the way that they used to silence people in the beginning, because it's just too many. And being not covered in this internationally protective status, that would subject them to possible lawsuits. I could totally see a civil suit being opened up against them if the censorship and the suppression of speech is continually being affected. I think that exposes them more than anything else to more lawsuits. In addition, whatever nefarious business that they have going on with their charity Archwell, then also that will be protected. So the tax evasion that we're all suspecting is going on, once those numbers come out, I can already tell you that there is one instance where the money or whatever commitment that they had been promising is simply not there. And that is with World Central Kitchen. Let me show you real quick what I'm talking about. At the end of December 2020, Meghan and Harry announced that they were helping to fund the creation of 4 new relief service centers. It did say back when they announced it that Archwell was going to be providing the financial commitment for the World Central Kitchen to build the 4 community relief centers. Now, this was allegedly supposed to have happened in 2021. So when I looked at the World Central Kitchen in their timeline for February 2021, states that they were working with Archwell Foundation to build these centers. As of today, there's no mention of the completion of Puerto Rico or India. In fact, there's no other update added about this project. To go a step further, on the 2021 tax return for World Central Kitchen, nowhere is it discussed that this project was in progress and the amount of money that was used to build it or to continue its program. Nothing. In 2021, Archwell website boasted that they were now working on their 3rd relief center, in which they were giving a financial commitment to World Central Kitchen. So how come in the 2021 annual report, as well as the IRS tax information for World Central Kitchen, that nowhere is listed talking about these centers that were being built? Also, why is it that the impact report, or whatever you would call that Archwell put out, has no information about that endeavor or effort? In fact, all they mention about World Central Kitchen was they helped feed 50,000 people. So my question now is, at one point, Archwell Foundation was taking donations through Archwell website. Where was the money going? Obviously, Harry has a reason for fighting so hard in getting this status back. I clearly laid out that it's not about physical safety, because he already has his security here in the United States and he's fine. And he barely goes over to the UK. So when he does go over there, it's not like the government and the royal family are saying, no, we're going to leave you high and dry. They have been more than willing to give him more than what he deserves. This is all about those special privileges. And that includes getting access to sensitive data, which personally I think is very dangerous for this couple to have, since they have already shown how they have abused their power. Also, taking money out of the American taxpayer's pocket in order to fund protecting these two idiots. In addition, this immunity is really concerning because we all know that there's something very nefarious about this couple in everything that they do and touch. Archwell Foundation in itself should be investigated. Also, let's say this court case with Samantha, Meghan doesn't want to have to testify. Meghan and Harry don't want to have to participate in that. As well as if they continue on their nefarious behavior from behind the scenes and trying to silence people, America won't stand for it. And you better believe that if they keep going down this path and keep poking the bear, trying to silence others with their coordinated intimidation tactics that they use when they execute and smear people that they want to shut down. And as you can see, Americans are getting pissed off. We want to have the voice in order to say, this guy has got to go, not be protected because he is a prince of the United Kingdom and we have to give him special treatment. My final thought on this topic is that Prince Harry is a guest in our country, and what we have witnessed is complete abuse of the freedoms that we have to offer, as well as asserting himself in our government. That's not okay. Prince Harry has been afforded already too many special privileges in a country where all men are supposed to be equal. And it is important that we do find out if our government did give Harry a special pass because he is a prince of the United Kingdom. If he did lie on his US visa application, then the consequences need to apply to him just like as if it was applying to anybody else. Enough. It's time for him to understand that there are consequences for lying, for deceiving, for manipulating. And I hope that the UK court system also understands this and sees that this has been one big manipulation filled with lies. There were never 5 options. They were the ones to propose this half in, half out, and have their cake and eat it too. Seen here.
So obviously what we proposed was sort of part-time, or at least as much as we could do without being fully consumed.
What do you guys think? Definitely leave your thoughts below. As always, I will be back soon with more content. But until then, please be safe, and I'll talk to you later. Bye.
I was such a fraud.